All right, everybody, you on the record.
All right. So again, thank you guys for being here. I'm attorney Marvin Arrington Jr. Carell Driscoll and I founded the HOA Alliance in sometime in 2014. We were homeowners just like you all, experiencing problems with our HOA, and went looking for answers on the internet. We found that most of the answers to the questions that we had were in the subdivision next door, the subdivision down the street, and the subdivision around the corner. There's a community app called Nextdoor, which some of you may be familiar with. At that time, Nextdoor was just starting, and we were able to find a lot of the answers again in subdivisions around the corner. What we found out was that the management companies and the law firms were talking across subdivision lines, but the homeowners were not talking across subdivision lines. And so we believe that there's strength in numbers, and we believe in educating homeowners so that everyone can have a better experience with their HOA. We found people either love their HOA or they hate their HOA. And we believe that education is the way to bridge the gap. So I'm going to dive back into SB406, talk about what it does. There were two basic things that were done. Chapter 17, it created Chapter 17A of Title 43, which is the Property Owners Association Registry. And so it creates a registration system with the Secretary of State. And so your, I'm going to say community association, or sometimes I may say HOA, but when I say that, what I really mean is HOA, condo association, co-op, property owners association. There's several different forms of HOAs depending on how your community is. But it establishes it, and so you don't have to register. You do not have to register with the Georgia Secretary of State. However, if you want to collect membership dues, then you do have to register. All right. And so most HOAs rely on those membership dues, and those membership dues are mandatory pursuant to the most declarations. And so if you want to collect on your HOA dues, then you will have to register with the Secretary of State. This starts January 1st, 2027. So existing HOAs, condo associations, property owner associations can continue to collect money from now until December 31st without registering with the Georgia Secretary of State. Starting January 1st of 2027, you will have to register with the Georgia Secretary of State in order to collect your dues. Chapter 17A of Title 43 establishes a five-member state board as an advisory slash policy body, and it codifies 12 rights of owners in Section 4317A7. It mandates a payment waterfall and 10-year record retention. Um, 10-year record retention is huge. The current law only allow for three. The current law only allow or required community associations to maintain their records for 3 years. And so requiring maintenance of records for 10 years is a big step, but it also requires a lot of coordination, because what happens a lot of times there's board turnover. And when someone moves out of the association or falls off the board, they don't turn over those records. But the association has a duty, pursuant to this new law, to maintain those records for 10 years. Again, currently the duty is to maintain all records for 3 years. It also sets up a hearing officer process and the right to appeal to the Superior or Magistrate Court. Now, this is very important because currently what has happened is homeowners have not really had any other option except to go file a lawsuit if they don't like the way they're being treated by their association. And so this sets up a process which homeowners do not necessarily have to have a lawyer. They can go, um, yeah, they can go to, they can file a complaint, get a hearing with the Secretary of State's office, ask for a hearing in front of a hearing officer, and uh, if they do not like that decision, if either party does not like that decision, either party would have the right to appeal to the Superior Court or to the Magistrate Court. And so that is a summary basically of what the new Chapter 17A of Title 43 does. It is for all community associations. So if you live in a mobile park home, if you live in a co-op, we don't see a lot of co-ops anymore, but before HOAs and condo associations, co-op was one of the bigger forms of these community associations. What one the other thing that it does is it amends Title 44, Chapter 3, Article 6, um, and establishes a minimum foreclosure threshold and notice. Previously, the minimum foreclosure threshold was $2,000 for community associations that were subject to the Georgia Property Owners Association Act, and I believe also for the Georgia Condominium Act. It also adds pre-suit attorney fee notice and a 30-day cure period. So basically, what they did, some of you may have heard the example I gave before of a homeowner owing $500 in dues or membership dues or association fees. The association pays $1,500 to hire an attorney, and now that person's bill goes to $2,000. Well, what this amendment does, it basically says before you can charge attorney fees, you have to send them notice. You have to send the homeowner notice and give them 30 days to cure. Hey, homeowner, you owe $500. We're giving you 30 days. Go back, please.
Oh, did I skip? Oh,
Yeah, just leave it alone. Go back. Leave, yeah, I don't. I was on. I mean, yeah, I'm still explaining this page.
okay.
Um,
Maybe.
so um, it basically works in homeowners' favor because basically the association has to give you an opportunity to cure, and what that means is an opportunity to pay the amount that you owe prior to them adding attorney's fees.
Can I
Now,
add
if you don't,
value, Marvin? I'm sorry. Go ahead.
yes, please go right ahead. Go right ahead.
I think the important point here is that now they have to send you a certified notice by mail. They can't do text messaging, email, or regular mail anymore. And that time period of notice starts when you receive the notice versus when they mail it. And so I thought that was pretty compelling. I'm sorry, I just wanted to add some value there.
No, no, that's very important. That is very, very important. And then it also um allows for judicial review of the reasonableness of attorneys' fees, and frankly of any fees, right? Um, but this is very important, and that ties into Section 7, which basically says that there has to be a determination of whether the attorney's fees are reasonable starting July 1st, 2026 of this year. So from for the next 6 days, your HOA or you as a HOA board member can add attorney's fees to someone's bill. But starting July 1st, you won't be able to necessarily add those attorney's fees. You may actually still be able to add them, but they will be subject to judicial review. And, likely you're going to need to start adopting. I'm advising HOAs that I represent to start attempting to adopt these policies now. Provide the 30-day cure notice. Go ahead and do all of the things that this new law requires now. Start doing those things now.
Yeah.
Um,
Yeah. Management companies too, their softwares, which are automated, can be catastrophic to a community association because if they're out of turn, they're violating the law. And that can determine if they can get attorney fees or not based on judicial review. So I just wanted to make sure I point that out because those are some of the things from a layperson, because I'm not a practicing attorney, that I paid attention to. So just
and
wanted to.
and then it also bars the association members, related entities, and family from bidding on your property if it goes into foreclosure.
Yeah.
Because a lot of times we'll see the association will use this against people and use it as a way to take their property from them. So
Yeah.
next slide.
Okay. And so you started on this, so I guess we're good to.
Yes, attorney fee notice changes starting July 1st. Senate Bill 406, Section 7 amends 44-3-232 by adding two new subsections F and G. Subsection F requires pre-suit written notice, a 30-day cure window, and an itemized fee list before an association may collect or be awarded attorney's fees. So if you're on the HOA board, you want to make sure you pay very close attention to that. I'm going to read that again. Subsection F requires pre-suit written notice, a 30-day cure window, and an itemized fee list before an association may collect or be awarded attorney's fees. Okay. Subsection G is also new, and it requires the trial judge in a bench trial to enter an order on the reasonableness of claimed fees before any award. Now, to some extent, this is not new. The law always said that the attorney's fees had to be reasonable. But if you were an individual homeowner, you would have to hire an attorney, go to court, go to trial, probably spend $20,000, $50,000 or more in order to prove that. Now you can do that through the Secretary of State and a hearing officer without having to incur those expenses. Because one of the biggest things in fighting the HOA is you're basically fighting yourself, and you're putting in your money, you're paying your money, they're using your money to pay for their attorney's fees, and then you got to hire an attorney. So it really puts a current system really put homeowners at a disadvantage, and this new system is an attempt to level the playing field. And these rules apply to all actions filed on or after July 1, 2026. Um, so if your action is filed, if you file an action for attorney's fees on or before June 30th, then you will not be subject to Senate Bill 406. But for any lawsuits filed after July 1st, it will be subject to this rule. There is a limited exception. With every rule, there's always an exception. Uh, and that exception is for emergency conditions involving public safety or property preservation, which can be carved out of the notice requirement.
Can I
And that's
offer an
probably
example here on this part?
yes. I was just going to say yes. I was just going to say that that's probably more applicable in condo associations and townhome associations. Go ahead, Corey.
No, that's what I was going to say, like a water leak that's impacting the neighbor downstairs, and the person is out of town. They need to have emergency access. This would be one of those limited exceptions. Now, it's not an emergency if a person's grass is over 3 inches. And so it's real tight just based on my understanding from the meetings and from what I've read. that they're going to really hold a tight fence around what they consider to be an emergency. So Marvin, I don't know, maybe this will end up in court where they have to define that with more clarity. So I guess we'll
Yeah,
see.
what's an emergency to some is not an emergency to other, right? I feel like I need a haircut right now. I need an emergency haircut, but it's not really urgent. It's not really that urgent, right? But let's go to the next slide.
Okay.
Before attorney fees may be collected, before they may be collected or awarded, three required preconditions. Number one, certified mail notice, initial written notice from the association or its agent by certified mail or statutory overnight delivery, identifying any outstanding fines or delinquent fees. Number two, a 30-day cure window. The lot owner must have 30 days from receipt. That's a very important point that Carell made earlier. Typically, when you mail something out, it's effective as of the day that it's mailed out. But they specifically put in here from receipt of the notice to pay the outstanding fines or delinquent fees. And so if they pay their money in that 30-day cure window, then you are unable to add any attorney's fees. If they don't pay within the 30 days, then you can start adding and billing them for attorney's fees. If you're on the board, if you're a homeowner, if you pay in the 30 days, then there won't be any attorney's fees added to your bill. Number three is an itemized fee list. An itemized list of the reasonable attorney's fees claimed must be provided with or before the demand. And again, the emergency exception is not required for these three prerequisites are not required in emergency conditions that involve public safety or property preservation. Um, so those are the three requirements for HOAs or community associations in order to be able, the three prerequisites before a community association may collect or be awarded attorney's fees. Currently, associations can just um, add attorney's fees to the person's bill. Going forward, starting July 1st, you'll have to meet these prerequisites before you can add attorney's fees to a homeowner's bill. Or if you are a homeowner, before your association can add attorney's fees to your bill, you'll have to meet these three prerequisites. Next slide.
So before you do that, can you reiterate when the certified notice start?
Yes, number two here, 30 days from receipt of the notice by the homeowner to pay the outstanding fines or delinquent fees. And I imagine, what happens if the person says they don't receive it or if they don't sign for it, right?
Yeah.
So, um, we're gonna have to see how all of this plays out. But, typically what I do when I send letters, I send it via certified mail. I send it via statutory overnight delivery. Um, Statutory overnight delivery, I think is just regular mail,
Hmm.
right? Um, and so I typically send it multiple ways. If we have an email address, I send it email, fax, certified mail, US mail, right? I want to make sure that there's no excuse and that we have taken all steps to ensure that someone received the notice.
Due diligence, right?
But yes, but 30 days from receipt of the notice. All right, next slide, please.
Okay.
All right. Fee notice, attorney fee notice traps to avoid. Common mistakes, skipping the certified mail or statutory overnight delivery. Starting July 1st, you're going to have to do that. Just saying that someone owes an amount, some type of ambiguous amount, a notice that doesn't clearly identify the outstanding fines and delinquent fees fails to start the 30-day clock. So you have to have an itemized list of the fees that you're charging. If that's a special assessment, whatever the fees may be, interest, late fees, whatever those fees are, you have to provide the homeowner with an itemized list of those items. Filing suit or demanding fees before 30 days have run is another thing that will prevent you from being able, if you're the association or board member, from being able to on collect those attorney's fees um, and omitting the itemization. We talked about that itemized list of the reasonable attorney's fees, and again the opportunity to cure, right? And then overbroad emergency exception, treating routine collection or trying to come up with some excuse as to why you're having to charge the attorney's fees and not following the process. Um, a lot of this is basically one of the reasons we've had these problems is because of people not following the processes and the rules. Sometimes it's the homeowner, sometimes it's the association or the management company. But this is an attempt to help make sure that everyone abides by the rules. And you want to have when you go to if you have to go to court, hopefully you don't ever have to go to court. But if you have to go to court, you want to go to court with clean hands. And what clean hands means, you want to make sure that you have followed all of the rules as you are supposed to. Whether you're the homeowner or the association, when you go to court, you want to go to court with clean hands. And if you have not followed the rules yourself, you don't have clean hands. Next slide, please.
All right, so I guess I can jump in here and help out. So one of the significant value adds moving that begins on January 1st of next year is the requirement for registration with the Secretary of State. And so why is that so important, right? The community association, common interest community, whichever name you want to brand, are required to register with the Secretary of State in order to collect dues, even fines, or even attorney fees, or have an attempt to foreclose on the property when they meet a certain threshold. So if they're not registered and they're being irresponsible, right, or the management company falls short, the Secretary of State will try to work with them to get on board. There is a fee. We'll talk about that as we move through. But what we're referencing here is Official Code of Georgia 43-17A, 1 subsection 6. And I've seen people complain about the registration process being a significant hit on the community. My community is over 250 homes. If the registration fee is $100, we divide that by 250 people, or homes, I'm sorry, then there's your cost, right, per home. And so what's required to file with the Secretary of State are all of your governing documents. That's the Declaration of Protective Covenants, your restrictions, your bylaws, Article of Incorporation should already be registered with the Secretary of State, but I would also go ahead and register that. If you're a board member, I know you delegate that responsibility to the management company. How can I put this? You can delegate responsibility, but you cannot delegate accountability. It's all on you. So you have to make sure it works, right? Officer information. which is generally hard for many homeowners or members to ascertain or identify their officers and members of the board because it's not widely published. They don't even update the Secretary of State corporation records, but now it's required. And look, here's one of the most important ones: a financial statement dated no more than 1 year prior to the filing of the registration statement, which again all occurs in January, and there's a renewal of $100 every year. So when
And the Secretary of State's office is coming up with regulations
yeah,
to help govern this stuff. So, these are kind of the outer boundaries, but the Secretary of State's office is allegedly, I'm sure they're diligently working towards doing it, but they will be coming up with some rules and regulations to help define all of these things. What do they mean by financial records? Does that mean just send the bank statements? Does that mean send a report or profit and loss statement? So I'm sure that there will be additional regulations and rules provided by the Georgia Secretary of State's
right.
office.
So at this point, we don't have all of the answers or requirements listed, but from my communications, that will include bank statements, balance sheets, all of the things that many of us have asked for on a number of occasions, and we get stonewalled. Now, if they don't respond, now you can file a complaint with the Secretary of State and try to get resolution. But some of that information should already be filed with the Secretary of State. So this to me, well, not to me, what I see here is overdue oversight on on the community associations. And some people compare community associations to micro cities. They're not managed or governed. There's no oversight. Now that's slowly changing, which is why we're happy to see the board come in place. So we'll see how that works out. All right. So there are 4 statutory grounds that have been specified in the Official Code of Georgia 43-17A-3, where the Secretary of State can withdraw the registration of a community association. The first one I like is false or misleading filings, right? Fake financial documents, right? Because when you establish a budget, the budget is in place to take care of operations and other items that the dues is responsible for. Willful violation. We see a significant number of complaints in reference to board members not even following their own rules, which represents the association. And one of the myths that I always hear is that, hey, when they get a new board elected, we have a new association or a new HOA. No, you don't. It's a business. You just have new leadership. And so willful violation can be conducted by past board members. So you have to, as a board member, stay diligent. Unpaid fee. If you don't pay that $100, you're not going to have the right to collect, and that will negatively impact the community association. And if
But
there's a
let me go back to the willful violation right quick,
okay,
because what that means for you if you're a board member of the association is that the association could be held liable for the wrongful acts of past board members. Doesn't mean that you as a board member did anything wrong, but maybe a past board member did not follow one of these rules, right? And the association may be liable. So if you are confronted with that and you see that the past association did not follow the rules, then you may want to quickly make a concession to the homeowner.
right. And so this is what I call the era of accountability. It's long overdue and we welcome it. And so I am happy to see this oversight. All right, so that foreclosure threshold. Now this is where it tends to be a little bit confusing, right? Where we talk about the old standard is if we get up to $2,000, I don't care if it's by way of fines, attorney fees, overdue dues, and interest. At $2,000 today,
or special assessments.
special
If
assessment,
you live in a condo, there could be a special assessment for the elevator of $1,000 or $2,000 per home.
right?
Uh, and this new standard applies only to regular assessments.
That is glorious to me. What you agreed to was to pay this community dues on an annual basis. It could have been monthly. That would count against this total number of what they say lesser of 4,000 or 12 months of regular assessments in arrears. That doesn't include the fines, interests, special assessments, and attorney fees, but never less than $2,000, right? And this, just based on my conversations and what I understand, applies to, let's say, a condo association. Maybe your dues is what, $400 or $500 a month, and you get to 12 months, you're not quite at 2,000. Let's say you may be at 1,800. I didn't calculate that out. Then you haven't reached that threshold. So as a community association, you cannot attempt to foreclose on a home, depending on what type of community association you are in, for less than $2,000. Again, if it's 12 months, then I can see where that will come into play with a condo association, but lesser of $4,000. So they've changed the dynamics here, and they've increased the amount that's required for an association to attempt to foreclose on you. And a lot of the costs in the past has been the attorney fees. I can't imagine owing $500 and my attorney fees is $10,000. So we have it here. So again, this is not the best policies yet, but it's a good start, right? So what count and what doesn't count? Marvin spoke to that a little bit earlier, right? All of this is regular assessments that's in arrears. Again, I'm being repetitive here on purpose. No fines, no interest, and no attorney fees. In the past, or over the previous years, I've witnessed community associations leverage fines to get people to that number so that they can attempt to foreclose on their homes. And I consider that to be corrupt behavior, but that we have it, right? So what does not count, again, fines, fees, late charges, interest, specific assessments for damages caused by an owner, what we call special assessments, and I love saying attorney fees, no offense, Mark. That's the biggest cost. And this is another thing, that we alluded to earlier, that 60-day pre-foreclosure notice. Again, we've hashed this out originally when Marvin was speaking. Certified mail or statutory overnight delivery. I would definitely stick with certified mail, guaranteed on everything. Just in my community alone, they got away from sending out certified mail because they said it was too costly. And it was always a requirement in the governing documents. I remember getting a notice by text. I responded to it, and of course I said, "Hey, I didn't give you authorization to text me something that important because I don't always check text. Send me a certified letter." I said, "If you want to send me a text and an email to complement the certified letter, fine. But as a board member, you are accountable. This is required. This is not optional. Certified mail is what I would encourage."
Let's be clear. It says certified mail or statutory overnight delivery. As a practical matter, if you send something certified mail, uh, Ray and Pookie and them, they're not gonna never sign for that certified mail. So I would caution you, if you are a board member, to not only send it certified mail, but to also send it statutory overnight delivery, which is via U.S. mail as well, as in addition to email and or text or carrier pigeon. Send it every way that you can so that you can show that you've been reasonable in taking steps and sending, and you took all reasonable steps to notify this person before trying to collect attorney's fees, and in this case, before trying to foreclose on their home.
And I'm poo-poo, by the way. I don't like signing no certified mail. I'm Pookie, Ray Ray, everybody. I'll let you. So this payment waterfall, I think, is really important to note. So generally, when people pay their dues, and if they have a balance on the account, maybe it's from a fine that you didn't agree with. Like me, I was being fined for my mailbox, and I always, when I paid, I always tell them where to apply my payment. But generally, most management companies, on behalf of the community association, would take that money and they would apply it to wherever they see fit. And so you could still be left with overdue dues that is growing just from the assessment. Now with this
Oh,
mandate,
let's be real specific. Hold on, let's be real specific.
okay, let's go.
What typically what happens now is pay if you owe money, it goes to pay off the attorney's fees first, right? It goes to pay off the attorney's fees first. So if you owe $10,000 and you send in and 5,000 of those dollars are worth are attorney's fees and 5,000 in assessments, the first 5,000 is going to go to pay off those attorney's fees. And so that's how people get in this never-ending cycle of ever being able to pay, because people keep fighting, and as you keep fighting, the attorney's fees grow. And so you paid 5,000 to pay off the attorney's fees. You thought it was paying off your bill. It did pay off part of your bill, but it only paid off the attorney's fees portion. And by the time you go to court and do something else, you got another 2,500 in attorney's fees. You pay another 2,500. Now you've paid 7,500 of what was 10,000, but you still haven't paid anything towards the $5,000 in principal that's owed.
And this is where people were frustrated. Now with a mandatory priority order as specified by Senate Bill 406, all payments initially, or the priority is regular assessment dues first, then special assessments, then if there's some specific assessments and other fees and fines, which attorney fees will fall way down on that priority list. And so this is a welcome change to public policy for Georgia, because I've seen many people who reach out, and if just focusing on the attorney fees, they don't give them an itemized list. They just give them an amount. And the first thing I always advise, ask for an itemized list of the charges. So this is something to put in your back pocket if you're a member. Well, if you're a board member, you're a member of the community anyway. But for board members, do not misapply payments. The waterfall is mandatory and it's not optional. You want to add something there, Marvin?
No, just again, this part of it doesn't start until January.
Yeah.
Uh, only the collection of attorney's fees starts on July 1st. All of the remaining provisions become effective on January 1st.
Right. So with the attorney actual part of this bill for July 1st is all about the reasonableness of the attorney fees and the fact that they're itemized, correct?
Yes, and the 30-day notice to cure before even assessing or trying to collect attorney's fees. You have to give the homeowner notice and 30 days from their receipt of that notice, and for them to have the opportunity to cure. And what this waterfall does, it basically reverses the system. It used to be attorney's fees first, and then they would apply it wherever else they wanted to. Now, this mandates that it has to allow you to pay off all of your homeowner assessments or regular dues first, which allows a homeowner to get out of this recurring cycle because their bill gets paid down first.
Right. And that minimizes the potential for foreclosure. So, and I welcome this, and I pray that I never get into this type of cycle. but many people have lost their homes to this, so, or the old process. And if you look at your governing documents, you agree that all attorney fees you would be responsible for paying. This changes it up. Well, it doesn't eliminate the attorney fees if it's reasonable or as determined by the trier of fact. But I mean, this is what we have. And, I wish they would have included that it was mandatory for the community associations to inform the members. So this is a part that where the members would be very interested. All right. You want to take this one, Marvin? Because I think this is very important. Partial payments. This has been a
Okay, yes, beyond the priority rule, there are two hard prohibitions. No refusal of partial payments. Currently, I've had clients that would say the association says, well, you owe us $5,000 and we're not taking anything less than $5,000. We're just not going to take it. We're not going to accept it. We're going to go forward with a lawsuit, forward with trying to foreclose on your home. Well, in this case, with this rule, you could pay $3,500 of the 5,000, get below the $2,000 threshold, and foreclosure of your home comes off the table. Uh, and basically, the association may not refuse to accept payment in any amount for any assessment. Even an underpayment must be accepted and applied via the waterfall provisions towards payment of dues first. No accelerated assessments. An association may not assess or collect accelerated assessments against any owner, including amounts that would otherwise not be due until a future date. Now, this is important because what happens currently is typically once the association sues you, they sue you not only for everything that you owed in the past, but they also sue you for all of the remaining assessments that are due in that calendar year. So let's say I filed a lawsuit against Corel tomorrow. Hey, you haven't paid, Mr. Driscoll, you haven't paid your dues for um, however long, and I'm filing suit against you now, and I'm going to accelerate the rest of the payments that you owe for the rest of this year because you've shown a pattern that you aren't going to pay. So we're going to go ahead and try to get all the money that we can for the rest of this year because you haven't paid anything for this year. So no accelerated assessments. Um, and we got a tip here that says make sure that you audit existing collection software now, because many systems default to paying the oldest bill first or pool fines with regular assessments. And so that will no longer be allowed. Um, and again, the new waterfall rules will apply. Membership dues first, specific fines, specific assessments, and then special assessments, and then any other fees like attorney's fees at that point.
correct. So this is what I consider one of our important slides. And by the way, we will send out the slide deck and I guess a link to the recording to all who registered. Now we're shifting into rights of the owners. And there are 12 rights where we consider homeowner rights. And so inspect and copy records. That has always been our rights as specified by the official code of Georgia. And those records are accounting records, membership records, and various other types of records that many community associations refuse to honor. But if you look at your governing documents, they've specified how and why and when you can request these records, which you're pretty much getting permission for them, and you state your reason for those records. Now it's being enforced through the Secretary of State, and that can be a part of your complaint. So within that 180-day time frame, which starts really July 1st, if you have some challenges with a community association, when January 1st come around, hopefully the Secretary of State will be on time. You can file a complaint. If you're being fined, they have a stay. We'll talk about that too. And the certificate of insurance. Asking for a copy of the insurance document for the community association, man, they would say, no, you can't have access. And what I've found, especially with the governing documents from my community, the official code of Georgia is more restrictive than our community. It allows us to get a broader access to those records. So that 10-year time frame, if they had those records on hand and I asked for them, they have to provide them. So we'll have more teeth in reference to this. Notice of member meetings. Many community association board members, when they send out notices, they're required to do it sometimes like 2 weeks before the start time, maybe even 30 days. I've seen some. They don't send out a notice of the meeting as required by those governing documents. Now, this shall be enforced, and you can make a complaint with the Secretary of State. Attend meeting of members. Member meetings must be called and held by the board at least annually. Well, in our governing documents, our board has to have 4 meetings a year, with one of them specifically as an annual meeting for the members. The other meetings, you don't get to participate, you just get to observe, unless the board allow you to. So you have to make sure you stay abreast of your governing documents and make sure you're in the know. But again, this is now an enforceable right through the Secretary of State. Access to common areas. Now, this has been a tricky one here. Access to common areas, amenities, and common elements per the governing documents. Notice they say state per the governing documents. So generally, if you're not paying your dues, you are restricted from access. I know in our community, it states that you can lose your rights or temporary rights to those amenities. And Marvin, you can help out here when you're ready. I disagree with being fined for my mailbox, but I pay my dues. But I'm restricted from accessing the amenities until I cure the account. In my opinion, that should have been stayed, which now I'm entitled to this. That if I disagree with a fine and I file a complaint with the Secretary of State, you put it on pause. It's like a freeze rate. You just pause in any other activity until it's addressed through the Secretary of State. And then ingress and egress, access to individually owned property. Now, this more so apply to condos, right? Like maybe you'll get restricted from using the elevator or being able to badge in through the gate to park. So now we see more of those rights being protected. And so for those who are questioning if any of Senate Bill 406 applies to the condos official code, it does. It's broadly, even though it's named after the Property Owners Act.
So this is real important. Just go back for 1 second. This is important,
Oops.
particularly if you live in a condo and you need to go, you have to access the elevator to get to your unit, right? And you've paid your dues, but you're disputing a fine. The way the law currently is, your access to the elevator and other common elements could be restricted because you're disputing a fine or attorney's fees, right? But as long as you pay your membership fees, then you should be allowed to continue to have the rights to ingress and egress in and out of the unit. In an individual home, you don't necessarily have to deal with this as much as you do perhaps in a condo or a townhome.
Right. And if I may add, I've operated on both sides of the fence. I've been a board member, board officer, and I'm a member, and I've seen how it operates on both sides. There's no 100% innocent person, or I won't say not innocent person. We have to question people's intent, right? As a board member, you have a significant amount of authority over your peers. You have to operate above board. The I won't say expectation, the ethical expectation we have for board members is 10 times above a typical member because you have the authority as opposed to a member. So as a member, they may just say some negative things about you. But as a board member, I've seen where I had just one little twig on a bush, and I got a notice with a threat to fine. So what I see Senate Bill 406, encouraged by Senator Donzella James, doing for us is to protect us from those overzealous individuals who think they're above the governing documents, and some think they're above the law, right? So this foreclosure process protection, we talked about this. Statutory notice, process requirements, and must be satisfied before any foreclosure action. You have to follow the law to the letter. There's no wiggle room. Amending governing documents. I've seen community associations file new governing documents without going through the proper process, right? Which involves the members. The members have to vote. So you have to follow your governing documents as well as the state law when trying to make those changes. And again, if you find that this is occurring, this is where you take advantage of filing a complaint with the Secretary of State. This is an attempt to minimize litigation costs, right? Which is pretty extensive in my opinion. Director duty of care. Directors must perform duties in good faith and with the care of an ordinarily prudent person. There are two or three other duties that board members have to follow. Now, this business judgment rule, from what I've learned, and Marvin, you can add some value here, is that it's difficult for, I'll say, members, and sometimes the courts won't second guess some decisions made by the board collectively, not individual board members, but collectively. And this is a part of your duty of care. You have to operate above board. Anything you want to add in there, Marvin? Because this is that's important to me.
Well, yeah, that's very important. I mean, as a director, as long as you're making your decisions in good faith, then those decisions can be protected, and you individually can be protected. Again, he's correct. The courts don't want to second guess the judgment of the business making a decision that the business believes is in its best interest.
And that's a collective. I
Now,
like to say collective for the board because it's not boiled down to one individual on the board. Like some people automatically think the president of the board has the authority or the power. The president follows, what's the word I want to use? The will of the board. So don't go out and make unilateral decisions on your own. And I don't know who all are board members in it. No one responded, so I'm assuming nobody. Now, you want to take the rest of these, a conflict of interest?
okay, yeah, conflict of interest disclosure. Directors must disclose any conflicting interest to the board regarding any transaction. I've seen things where board members have been paid themselves for performing tasks, which is generally um, not allowed under most governing documents. And I've also seen a- attempts to circumvent because the board member themselves won't be getting paid, but their son will be getting paid for doing landscaping, right? And so that could certainly be perceived as a conflict of interest if there's any conflict of interest. And typically any potential conflict of interest, disclosure of that conflict is required. Household composition carve out. Owners are free from governing documents that interfere with the freedom to determine their household composition, but associations may require single housekeeping unit occupants and limit the total number of occupants and fair share of common facility use, including parking. So what this addresses is, I think what this attempts to address is boards saying, oh, well, that person is renting from you. You've got somebody in your house and they're renting from you. Um, no, that person is part of my family. It may be my cousin, but they are part of the family. You can't tell me who my family is. The other area where we see this come up a lot of times is in Airbnb rentals and things like that. And so the question becomes whether it's a single family use or not if you're renting it out to multiple families. But I think typically it's still the use is still single family use, even if you are renting it out to multiple families. Um, and order owners may also challenge any discriminatory practices as authorized by state or federal law. So, if you um, are LGBT, they can't say, "Oh, well, you can't have another person of your same sex residing in the home with you." They can't, discriminate based on race, sex, age, or gender, or any other reason that is protected under state or federal law. And again, I think a lot of these I think SB 406 is likely going to be adopted around the nation by other states in various different forms because I believe this is the guidance that we need. I wanted to back up a little bit. We talk about inspecting records. We talk and we also talked about the different types of community associations. So most community associations are HOAs, which are governed by Title 44 and by Title 14. Title 14 is the Georgia Nonprofit Act. So most community associations are Georgia nonprofit corporations, and that's why they have been governed by the Georgia Nonprofit Act. The property, the land inside an association is governed by Title 44, which is the Real Property Act. The Condominium Act came together and brought everyone under one roof. It brought all condominiums under one set of rules. More recently, we've seen the Georgia Property Owners Association Act, and we've seen a lot of HOAs converting from a regular HOA to a POA. The POA gives the association more powers to collect. In a traditional HOA, the HOA may have a lien but may not be able to foreclose on your unit. And the problem with that is people will say, oh, well, I'm going to die. They can get it after I die or after I sell it. But the association still needs the ability to conduct ongoing business. And so, you know, having a lien against someone's house does not give you the money to pay the pool bill or the light bill or the gas bill on the association's behalf. So I just wanted to bring those things out and then also talk about I put a link in the chat, OCGA 14-3 1602 describes the process for inspecting and records and what you must ask for, what you must tell them. You must give them a reason why you're asking for it. And so, again, these are just, uh, some of the main basic rights that SB 406 protects. You can go to the next slide. And really, you can go two forward because I think we already did that one.
This
All
is
right, so now, yeah, go ahead.
no, I was saying this is just a little bit of I won't say advice, just trying to make sure we focus on some of the high value items from tonight. Like, so threshold filing rules. And again, the Secretary of State hasn't fully flushed all of this out. This is what we've garnered so far just from some of the conversations. Any person residing in a owner's development who claims damage by an association's action or inaction. These are the people, this is who can file a complaint with the Secretary of State. At what point do you file that complaint? Your time frame is that from the time you have realized some type of damage from action or inaction up to 180 days, you have to file that complaint. And this is what I always tell everybody: document, document, document. I don't depend solely on phone calls to a management company or talking to a board member walking down the street. If you do end up on a phone call or having a conversation, do a follow up, have a follow up with an email, maybe even sending a letter. I do email. You just want to make sure you document your interaction. So this is the win. You have it within that 180-day time frame.
So
Especially,
what that means, hold on. What that means is if the association, if you believe the association has damaged you, you have 6 months to file a claim with the Secretary of State. If you don't, your right to file that claim may expire, and you may not be able to bring that claim or seek those damages.
right? And that's, that time, that 6 months can go by just like that. And so you want to make sure you are paying attention and staying on top of this. Where you file the complaint with the Secretary of State. How? We have been told it will be an online form. We don't really know.
Looks like he froze up. Filed a complaint with the Secretary of State, and who will appoint a hearing officer to conduct the proceedings. You froze up for a second there, Corral, so I just finished that part off for you.
That's good.
Filed a complaint with the Secretary of State. They will appoint a hearing officer, and the hearing will be scheduled. And again, waiting to get all of the detailed rules and regulations from the Secretary of State.
And this is where I would expect members to pay close attention. So, so what does that look like, right? So we can talk through a few scenarios, right? So when I look at, remember we were talking about the threshold of $4,000, no less than 2,000, 12 months. Add up 12 months of your regular dues. If that number is less than 4,000, that's the limit, right? If it's more, the limit stops at 4,000. The limit can never drop below 2,000. Only regular dues count. Fines, late fees, special charges do not impact that threshold for foreclosure. And this was very important to all of us who lobbied for Senate Bill 406. And I'll just say grateful that Senator Jane and a number of other senators stayed diligent on this to try to get this through, which started out with listening to everyone's, I won't say complaint, experience with community associations to get us to this point. So when we look at scenario one, and this is when we're thinking about the low threshold, or what they call poverty community associations. 12 times 100 is equal to $1,200. And that's where that 12 months come into play. That limit, it should equal to 2,000, with the dues equal 12 months equaling to 1,200. That's less than the 2,000. So the floor kicks in. The HOA cannot start the foreclosure process until you owe at least 2,000 in regular dues. Okay. If I look at scenario three, which is at more of a mid-level, that's 12 times 250, that's $3,000. The limit is 3,000. So for 12 months of dues that equal to 3,000, that falls between the bottom of the threshold, 2,000, and the top of the threshold, 4,000. So the limit is 3,000. The HOA cannot start foreclosure until you owe at least 3,000 in regular dues. Notice we're emphasizing regular dues. And then, of course, in our final scenario, where the limit is 4,000, you see it's 12 times $500 a month, right? We get into what I call the condo territory. That could be $6,000. So 12 months of dues is equal to 6,000. That's more than the 4,000. So the cap kicks in. The HOA cannot start foreclosure until you owe at least $4,000 in regular dues. So this is how we're trying to
Or
clarify. Go ahead, go ahead.
let me just add one point. It is 4,000 or 12 months of your regular due. So if you are behind by 12 months, they can start foreclosure on you if it is above 2,000 and below
Correct.
4,000, right? So scenario two that we're looking at here, in scenario two in the blue, you could be foreclosed upon if you miss 12 months. But guess what? They have to accept partial payments. So if you send in $500 or you send in $1,000, I guess you probably have to send in 1,500 or 1,250 or some 1,750 in order to get below the $2,000 threshold.
Where the goal
So
is to avoid the thresholds.
yes.
Right. So um, I just wanted to make sure that we touched on these examples just for clarification, because to me that portion of the law was the most confusing. Applying the threshold, because some people would say, "Oh, now it's $4,000," right, without taking into account the 12 months, right? So when we've derived from the policy without clarification from the Secretary of State, the 13-step workflow, which is really steps 1 through 7, right? So if you feel like you've been wrong and you've gathered the evidence, because you need to be prepared to submit your evidence, file a complaint with the Secretary of State within that time frame. Once the Secretary of State receives that complaint, I think if my memory serves me correctly, it's 30 days. They have to assign a hearing officer. But during that time, when you file that complaint, that's when that freeze rate come in and you have a stay. They can't fine anymore. They can't hit you with additional fees. They can't keep sending you letters. It has to stop. And then, of course, the hearing officer investigates the written statement of facts. Notice what he's investigating: written statement of facts. Collect your evidence. Don't wait until after you feel violated. If you're getting letters, keep your letters. If you're getting emails, print them out to PDFs. If you're having phone calls, keep a phone log and follow with emails. Collect your evidence, because the hearing officer starts his investigation from your complaint and your written statement of facts. The hearing officer will have discretion. I don't know how broad that will be. We'll get more details soon. Order the hearing and give notice of time and place. So maybe in your statement of fact, you may request a hearing, but it's at the discretion of the hearing officer. Okay. A hearing is conducted by the hearing officer. And then, of course, after the hearing officer, I'll say, make a ruling and come to a conclusion, and he reports the finding and renders conclusions to the complaint, to the complainant and the respondent. And you have 15 days to cure it. But they do offer.
So that's typically done in writing.
Yes.
That because it has to be in writing, because if that's not done in writing, there will be differences of opinion. People will remember one part and not another part.
Right.
So that opinion has to be given in writing.
And I'll let you take the rest of this right here, Marv, starting with that 15-day
Okay,
complaint.
yeah, 15-day compliance window. So if you don't like the decision of the hearing officer, You can appeal that decision within 15 days. But the automatic stay that was in place before on the fines expires upon rendering of the hearing officer's conclusion. The hearing officer may extend, however, that automatic stay for an additional 15 days. Um, and I think the hearing officer may also allow an additional 15 days, um, for if you want to file an appeal to the superior or the magistrate court. Um, if settlement is not affected, the hearing officer, complainant, or respondent may bring an action to enforce the claim. All right. So if settlement is not affected, the hearing officer, complainant, or respondent may bring an action to enforce the claim. The non-prevailing party at any hearing owes a $100 administrative service fee to the Secretary of State.
That's a big difference from attorney fees.
Yeah,
For
that's a big difference, but I mean, I don't know.
that's for the
You
hearing.
know, yeah, and so that's good. It's $100 registration fee, and there's also $100 administrative fee if you lose. So that's not the end of the world, right?
Right.
And then you can appeal to the superior or magistrate court. De novo review, and de novo review is very important because what that means is that when you appeal, they have to start over from the beginning. A lot of times when you appeal, if you appeal from Superior Court to the Court of Appeals or the Supreme Court of Georgia, they they assume that all of the facts are true and they only look for an error of law. In a de novo appeal, all of the facts have to be heard over again from the beginning by the new court.
So, so, so when we think about a checklist from the board members who represent the community association and individual members who are submitting a complaint, you have to do your due diligence to protect the interests. I'm speaking to board members of the entire community, right? You are looking out for the collective, right? Not a one particular member. And as opposed to the complainant, you're looking out for your household uh, best interest. So if I'm a respondent, I'm going to pull the complete file on the subject lot and dispute. If there's a dispute, maybe you'll come around and agree. Confirm all collection efforts on subject fees are suspended, right? Remember that automatic stay. Identify the governing document provision at issue and supporting board member minutes. I'm sorry, board minutes. That's one thing that I used to do a lot whenever we dealt with people who push back on specific violations. I always made sure I identified the governing document, the sections that we can reference, and I noted it. So just for our argument or for discussion with the board members, designate a witness with authority and personal knowledge. If you have a management company working for you, 9 times out of 10, that may be who you designate. But I do firmly believe that some board members should be abreast of everything and know all of the details, if not all, and prepare an exhibit list. Man, I spent so much time in litigation, I felt like I was going through training. And I learned all about all of this stuff, notices, obtaining, getting the hands on the ledger, any correspondence between the complainant and the association. And then, of course, you coordinate with counsel and the management to attend. I don't think they are allowed to go to the hearing. I think this may have to be um, a board member. I'm not sure. It's not been clarified yet, but we'll see. Now, from a complainant perspective, You want to keep everything but nothing. I'll just keep it simple. All email communications, your telephone log. You want to make sure you have all your evidence together. Photographs, like when they were finding me about my mailbox, you don't think I put my drone in the air and went around and took pictures of mailboxes? And my next move was to request a list, request all fines during a certain time frame. So collect your evidence, be detailed. Otherwise, you can end up being the one paying that $100 and plus any other things that you may owe. Identify any witnesses that have personal knowledge, confirm the filing fee and any administrative requirements have been met by the association, and plan for the 15-day post-hearing compliance window. You
So
got
that
it.
brings us, we're at 7:33. We want to be respectful of everyone's time.
Okay.
And so,
We'll close with that.
um,
Let's close
yeah,
with
we'll close with the key takeaways. July 1st, 2026, attorney fee notice rules take effect. Certified or statutory overnight delivery, 30-day cure period, an itemized list of any fees. January 1st, 2027, the remaining parts of SB 406 take effect, including the registration that is required in order to collect any assessments or fees. The foreclosure threshold takes effect January 1st, which raises it to $4,000 or 12 months of regular dues, but never less than 2,000, and only the regular assessments count towards that amount. 10 years for record retention, which is a 7-year increase over the current 3-year records retention, and 180 days to file a complaint against your HOA with the Secretary of State if you believe that your HOA has done something wrong. We want to thank you guys for being with us tonight. Um, Hopefully you can. I see that there are a lot of other questions. Unfortunately, we don't have time to answer all of those questions here tonight. Um, but we have a website with a couple of different websites with a ton of
that.
information. We definitely invite you to visit HOAalliance.org and also Georgia HOA Alliance.org.
And we'll send
Um,
out the slide deck to everybody, and we'll provide you with a link to the frequently asked questions, and we'll work on getting you a response to the questions that have been submitted. So thank you, guys.
and the other thing I would say is we also have videos on our YouTube channel.
Yeah.
We have let me see if I can pull that link up and get that link to you 1 second.
Mhm.
Yes, here it is.
And when you see Senator Donzella James, Councilwoman Linda Pritchard, I'm just thinking of some of the people who have been in the fight uh, since as long as I can remember. Make sure you tell them thank you because they were very diligent. And of course, Commissioner Arrington was all about the homeowner bill of rights. So make sure you all take some time to thank them. And
Yeah,
don't
we've been
invite
fighting for
them.
this. We've been fighting for this since 2016, and the real estate lobby pushed back against it. The HOA lobby pushed back against it.
CAI.
And- yeah, and so we are so glad to have SB 406. I think it is record setting, and that everyone around the country, all other states will be adopting similar regulations on these HOAs because some of them have gotten out of hand. And again, it only takes one bad apple to spoil the whole bunch. So visit our websites, HOAalliance.org. You can visit our YouTube channel. We have a lot of our past sessions that talk about a lot of different issues on our YouTube channel. So please make sure that you get a chance to visit that as well. And if you have any follow-up questions, please give us a call. We do plan on hosting a session in November, our Georgia HOA Alliance. This year, we've already held a HOA boot camp in DeKalb County and in Douglas County. And in November, we plan on hosting our Georgia HOA boot camp. So we look forward to seeing you there. We thank you all, and we hope that you have a blessed evening.
One thing I do want to say, be on the lookout for more detailed, deep diving into the different aspects from a board member's perspective, members. And I just uploaded the slide deck to you guys. So it was probably, you probably can just download it. But we'll make sure we get it out. Thank you all for taking time out your busy day. And I'm glad you joined us. Thank you.
Thank you. Shameless plug, if you need an HOA attorney, Marvin Arrington Jr., I'm at Arrington and Phillips. I'll put in
Could you
my
put your name,
website there.
please?
Y'all making me nervous.
Thank you.
And I put my email address in there as well. So thank you guys again. And God bless you. Good night.